Should say
So,
for anybody on the call, you can go into the chat function and send questions as they come up, please.
sure. So the Paycheck Protection loans are available to companies with 500 employees or less. And the forgiveness portion works is that an 8-week period after the loan is dispersed, you need to document certain costs. And costs are payroll costs, interest payments on mortgage obligations, rent costs, payments, and utility bills. And if you document that during this 8-week period, at the end of it, you can take that documentation to your lender and they will give whatever loan amount is equal to the documentation that you submit. So potentially you could scenario where you come to the end of that 8-week period and maybe your loan is higher than the cost that you've documented. So in that scenario, what happens is the unforgiven balance becomes a conventional loan. And that loan has relatively favorable terms. It has, you can defer the loan from that date that you applied for forgiveness for a minimum of 6 months up to a maximum of a year. And the interest rate loan is not going to exceed 4%. That's what happens if you don't have any, or if you have additional loan proceeds that haven't.
Thank you. Tom Galvin, I think you're on here. Thank you, Eric. Tom Galvin, a question that came in was what benefits as a small business company with, in this particular instance, one employee, but let's just talk about a small business. What sort of things are they eligible for?
Well, any small business, no matter how many employees you have, would be eligible for these programs that Jonathan outlined. What I've seen with the small businesses that we've been working with in these past couple of weeks as these SBA loans have been rolling out is that companies just, everyone has suffered an economic injury as a result of this coronavirus crisis. And the SBA, from all indications that we've been interacting with them, is that they want to get these loans out as quickly as possible. They've actually been working really well about making their website more user-friendly. If you were on the SBA website like 3 weeks ago, it was a very clunky website, looked like something out of the 90s. Now it's very user-friendly. You can just upload the information, the documents you have, including from the IRS, which is really important. Just drag and drop and place them in the SBA website. And they're going to get back to you. They promise fairly quickly. Obviously, they're dealing with probably thousands or millions of loan applications right now, but they're doing what they can. And if you have one employee or if you have 499 employees, you are eligible for these programs.
And maybe I can ask Jonathan, are commissions included subject to that $100,000 salary limit in a 12-month payroll calculation, or do we know that yet?
Yes, we do. So payroll costs are a defined term under the statute. They do include commissions. They include salary up to a maximum of $100,000. They include wages of other forms, cash tips, payments for vacation, leave, health insurance costs, retirement benefits, even state and local taxes on employee compensation.
Okay, thank you. Let's talk a little bit, Shruti, maybe you can answer this. There's a question from one of the audience members. What would happen if your employees make more in unemployment and don't want to get hired back? Are there any prepayment penalties?
So that's a great question. And there are no prepayment penalties, which is the best part about this program. So the answer to that question is no. And the goal for the program is to just keep your employees with the benefits that they can have right now, with the goal to continue keeping them going forward.
Thank you, Shruti. And maybe I'll ask you this, or Jonathan, or Eric, whoever wants to jump in here. What if you pay commissions to an outside real estate brokerage?
So I can.
Go ahead.
Okay, go ahead, Eric.
So the statute or the act references independent contractors and payments to contractors as employees. I believe that would be included.
Okay, thank you. And then Shruti, can you talk a little bit about, we've looked for farming, the farming industry. There was a question, is farming excluded from these programs, or what do we know about that?
Yeah, so farming is included. So agricultural enterprises do fall within the definition of small business for these programs. But there is a very interesting caveat that these enterprises have to be collectively, so collectively means including their affiliates or subs, have to have a gross receipts of less than $750,000 in annual amount. But that being said, there is also this catch that the USDA is going to be coming up with a bunch of other programs specifically for the agricultural industry. And so there might be some overlap or some sort of a way where companies or enterprises that are beyond the gross receipt threshold as well can benefit from the funds that have been set aside.
Oh, thank you so much. And I should preface all this with, we're not trying to offer you legal advice right now. We're trying to answer questions. And so if you need legal advice, please call us or call your lawyer and get that from them. But we're just trying to be informational and help the situation, because I know everybody's sifting through this. And we've got, I think, 7 people at the firm just full-time doing this, trying to help. Our goal is to save all of our clients' businesses. So that's what we're going to do. Okay, is it 500 associates per location or 500 associates in the aggregate to qualify for the loan? Who wants that?
I take that. So that depends on the type of business that you have. There is an exception for businesses that are in the hospitality industry that has codes in this NACS classification. So if it's restaurants and hotels, have 500 employees are at a given location, but you have more locations, and in aggregate you have more, you would still be able to apply.
Okay, good. Thank you for that. Shruti, let's talk a little bit about net operating loss and business interest deductions under the CARE Act to increase access to cash. Can you talk to us about that as you're handling this for a lot of small businesses?
Sure, absolutely. So typically when a business loses money in any taxable year, the business records the loss as a net operating loss, and it's used to offset its future taxable income. So for example, if you have a bad year, the federal laws allow you to get a tax break in the years to come to help you recover. Generally, the NOLs or the net operating losses can only be applied to future years, and they're capped at 80% of your taxable income in any period. The beauty of the CARES Act is that businesses are now temporarily allowed to use the NOLs to offset taxable income from past years, so 2018 through 2020, and for the next 5 years. And it also suspends the taxable income limitation of 80% and is allowing you now to use your NOL to fully offset income. So it's very, very good for small businesses, especially if you're trying to recover from, maybe you had a few past years with some loss and low profit years. So definitely talk to your accountant and get some benefit from this.
Thank you. Tom, there are some questions about the rental renters forgiveness, how landlords are to be treating renters, how long we're required to forgive rental payments, all of that. Can you talk a little bit about that, please?
Sure. Governor Ducey signed an executive order working in conjunction with the banks that you cannot be evicted over the next, I believe it's 90 days. But you have to show, and this is really important for landlords and tenants to know, you have to show that you suffered an economic harm. Either you lost a job, or you're caring for someone who is suffering from the coronavirus, or you yourself is suffering from the coronavirus, or there's been a substantial loss of income. And that must be documented to your landlord. So if you want to pursue those remedies to get alleviation for your rent, you must document an actual harm to your landlord.
And this is applying to residential?
Yes.
Yes. Okay. All right. Perfect.
And on your primary residence.
Good. Um, any input on health insurance? Some people are talking about what do we do with our employees if we want to make sure they keep health insurance, or do we have some sort of relief with the health insurance under the act? Who wants to take that? Maybe Shruti?
Sorry, I was looking for my mute button. Yes, so benefits are covered and they can be used from the loan proceeds. So when you are looking at the amount that you want to seek as a loan, make sure you're including all of your health benefits for your past employees. An interesting thing that we've been trying at Rose Law Group to find out for our clients are that now is a good time if you're getting funds. In addition, you're getting 250% of the amount of money you were spending previously. So can you use this amount to hire new employees and actually expand your business and also get better benefits from them? So we're working with lenders to see if this can be possible, but I would highly encourage to include the higher amount of benefits for your employees, whether they were terminated previously or you're looking to hire new ones right now when you're looking to categorize the amount of money that you want to get as part of the loan.
Thank you, Shruti. Let's talk about, there's a question from the audience. What if you're a landlord and your tenants are terminating and not renewing leases due to job loss? Would you be eligible for applying for either of these loan opportunities?
So is the question as a landlord applying for the loan opportunity?
Yes, as a landlord. Yes.
Yeah. Yeah, so I think absolutely, but what I would say is, what I would recommend is talk to your tenants and set up a program for all of your tenants where they can talk to you and figure out how you can come up with business terms that you can newly negotiate and document. Any deviation from your existing lease terms should be documented. I know Cameron and I are working a lot with a lot of our existing commercial lease landlords to get all of this documented. But in terms of also going out and seeking these loans, Eric, you can correct me if I'm wrong here, but I think even a commercial real estate owner can go ahead and get these loans, correct?
Yeah, I believe that's correct. Yes.
Shruti, can you expand on some of the modifications, commercial lease payment timing and things like that, as well as there's been a lot of questions, I've fielded a lot of questions about the force majeure issues regarding leases. And I know we have a lot of commercial real estate guys on the phone right now.
Sure. Great question. So proactively address both your payment obligations and timing of obligations. We have seen a lot of landlords defer their payment obligations and also reduce payment obligations. But at the same time, you need to understand that this is something where you're renegotiating your business terms. And while it's nice that you want to give a break to your tenants, just keep in mind that documenting this is very important. When it comes to force majeure, I think typically what we've seen is that force majeure provisions do not allow for rent abatement. The rent still continues and you have to pay. But I think what really needs to happen right now is proactively tenants and landlords need to sit down and document any changes that they're making in their lease. And also, if you're a landlord, just keep in mind that the lenders, and if you have financing on your property, lenders are very amiable to renegotiating business terms right now. So we represent at the Rose Law Group both lenders and borrowers, and we're seeing both sides being amiable and coming up with solutions that can, either defer payments or figure out a better interest rate or what have you. So talk to your lender proactively right now. And see what kind of an arrangement you can come to with them, but make sure it is in writing.
Do landlords have any obligation to work with tenants for rent abatement if the tenant is designated shut down by a government, like a gym? This was a question from the audience. I think it's a very good question.
Yeah, I would say that's a pretty subjective question because you have to look at the lease and see what language you have in your lease. Does it allow for quiet enjoyment? Does it allow for force majeure shutting down? Again, that being said, no matter what it says in your lease, and I think Cameron can also talk to this a little bit probably, but you can always open up business terms and renegotiate your document. And now is the perfect time to do that. I don't think there is an obligation under statute to do it unless there are some new situation or new executive orders that come up now, given that this is an evolving situation. But I would say pull up your lease and your document and see what's in it.
Perfect. Eric, do you have any thing to add to that?
Well, I think that the guidelines as far as like eviction moratoriums and things like that they're only applicable if you have a mortgage. So, and landlords that have federally backed mortgages also have some options as far as having their payments with their payments. And so kind of I mean, as far as the federal level goes, it's sort of unique to them. And then the Ducey executive order, you know, one thing that I think that we should mention is, number one, is that, you know, the tenant impact, it's not everybody. It's tenants that are under unique circumstances and are more directly impacted by the disease itself. So they've been directed to be, because, you know, they actually have coronavirus, or they've been in contact with a family member, that type of situation. But one thing that's developing right now, just over the last couple of days, is that the Department of Housing is putting together an eviction prevention program to allocate money to tenants precisely that situation. They can't pay their rent. That's something really encouraging landlords to explore with their tenants that are in the situation, because there may be funds available there that they could to actually make their rent. So
yeah, Jordan, just to add to Eric's point, the rent abatement for housing doesn't apply to commercial leases.
Thank you. Thank you. I see Dan Gauthier, who's been really advising lots of people for us on the line here from our office. If you have anything to add, I know we said we wouldn't take too much time here, but we just wanted to provide some questions and answers and a service to the community. So I don't know, Dan, if you've got some other things.
Yeah, thanks, Jordan, and sorry to join late here. I don't know that I have anything to add based on what Eric and Shruti have been saying. I think that Shruti's point to look at your lease is a very good one, because I'm finding that in answering questions on the day-to-day from clients, a lot of those are answered by pulling up that document and seeing what it actually says. And I'd also just add and piggyback on what's been said already, to the extent the dialogue hasn't been opened between, if you're a tenant or a landlord or a lender, you know, whoever you are, it's most likely going to be in your best interests, based on my experience so far, to open that dialogue and to have that conversation and get those negotiations rolling. You will most likely, regardless of you know, the situation or your capacity in a particular deal, be renegotiating, modifying, terminating a relationship or several relationships over the course of the next 3, 6 months or a year. So it's best to proactively address that as soon as possible, in my opinion.
There's a question from the audience that I think is sort of interesting. And by the way, did we just see Elliot Pollock with a face mask on, or did I get that wrong? I don't know. Good, good, Elliot. I'm glad you're practicing. You're going to be very safe. Hemp or marijuana, do those businesses, do we know, does anybody have any opinion? Again, we're not providing legal advice, but do those businesses qualify under the CARE Act? Or there's two different things, so maybe one does, one doesn't.
Yeah, so I can take that one. The CARE Act is silent as to whether it applies to cannabis businesses, but as a general rule of thumb, you're probably not going to get a lot of help from the federal government when it comes to those. Hemp is a little bit of a different question, given that it's no longer governed by the Controlled Substances Act. I think that's kind of open to interpretation at this point, so I wouldn't gamble too much on it, but that's a possibility. Medical marijuana, on the other hand, though, is not an option.
Thank you, Jonathan. A question from the audience, and I've seen it come up a couple times, but when applying for these SBA loans, now I know the banks have not yet received guidance from the SBA, so that we don't necessarily have all of that they need, and certain lenders are requiring you to gather certain information and others are other information. But what if you're not credit worthy? What if you're not, typically would not be approved for an SBA loan? Are you out of luck on this, or what are your thoughts? Maybe Shruti has that, or?
Sure. So for the payment protection program, you don't have to have any credit worthiness requirements. The same, I believe, goes for the EIDL grant opportunities or loan opportunities, unless at some point you decide to roll that over into an existing SBA loan or some other program, in which case there may be some credit worthiness requirements. So, but this is very specific to the EIDL or the PPP, as we're calling it. If you are going for a traditional SBA backed loan, those definitely do have creditworthy requirements, and you will have to go through that. That being said, at this point in time, I think if we were advising someone, we would say that instead of going through the traditional SBA loan, try to fit yourself within the PPP or the EIDL program.
Thank you. Here's a good question. You're in escrow, you're closing in 60 days on something, on a commercial project. Here's a motel, but let's just say whatever it is. Can you step into these helpful programs as the new owner, which would affect your decision to close? Is anybody who wants to take that? It's a good question. Silence. That's great. Stump the attorney. We're not playing that game. We're not playing that game. We have answers.
No, I was looking at Dan, because I think we might be in a
I was looking at you.
situation. Yeah, I think we might be in a similar situation. So I was wondering if this is one of our clients who's trying to get an answer out of us quicker. The answer to that is it depends. It depends on how you are able to show, or whether you're able to show that you qualify under one of the programs. And I think, and please, this is not legal advice, because we really don't know what the specifics of your individual situation is. But if you are able to show that it is because of this economic disaster that you were not able to bring the funds that you were supposed to have to close on this, then you might be eligible for the EIDL pretty quickly. And also, perhaps Eric referred to this previously, but just applying for the EIDL gives you $10,000 straight in 10 days, whether you qualify or not. So these are some options, but the answer is it depends, and it'll depend on what your business model is and why you don't have that money to close on the property right now. And we can certainly help advise on that if we have a better understanding of the documents and what the deal terms are.
Perfect. Thank you so much. And we just have a few more minutes. So if you have questions, go ahead and write them in, and we're happy to talk to you at any time. One quick question, maybe for Tom Galvin. This essential services ban, I know right after that essential services, the essential services or the order yesterday went into effect. I think I got 12 different calls and emails from people saying, like, can I go to work? Can I have my employees come to work? And actually this was all sort of born by a call that Nathan called me and said, there's a bunch of guys in construction that are asking me if they got to pull people off the job site. You need to send out some message to people to let them know that's cool. They can keep working. It's essential. And so that, I think within about 10 minutes, we, decided to hit send and sent that message. Plus we wanted to provide this information. But what else could we say about essential services? I know, we can certainly go get drive-through and, take out food. Thank goodness, because I can't cook and my family would starve. But what else do you have, Tom?
Yeah, the essential services question is a good one, Jordan. Doug Ducey's announcement yesterday that encouraging people to stay from home only slightly modified what has already been in place. It went into effect at 5 p.m. last night. It's going to last through April 30th. Arizona is considered to have one of the more broad definitions of essential services around the country, but Doug Ducey is taking more of a gradual approach, and I think he's going to just take things on the fly and on a day-by-day basis, and will make adjustments accordingly if he needs to tighten it up. But one of the questions we received by email is restaurant services. They're still listed as an essential service, but one of the restaurant owners asked us, hey, we have a back of the office accountant person working on this. Are they still considered able to come to work? And the answer is absolutely yes, because they're still providing the service of the restaurant. The restaurant has to function with someone in the accounting desk to account for everything going in and everything going out, the accounts payable, as well as all the items and things that are being procured and the employees that have to be paid. Professional services, including law firms and accounting firms, they are considered an essential service. Right now, you still have some personal services that are still in operation. The only thing that we saw that was affected yesterday were some retail operators.
So, and we have been giving opinions to various clients over the last day, just so they have a legal opinion to show, I don't know, their lender, their employees or what have you, as to if they can go to work. So there's peculiar situations. Like I see there's a question about engineering services, and I think if it's supporting real estate, probably the answer could be yes, but we need to think through that a little bit more carefully. Okay, so we've 12:30. Okay, I'm going to ask the one last question. This is a good question. Is yoga allowed to go to exercise yesterday? Does anybody want to take that? It's very interesting. I know you can go golf, so. Well, Rose Law Group really wants to help. Like I said, we have a goal of helping 100% of our clients through this crisis with whatever we could do for the community. We want to do that. We'll continue to do these little sessions. And on Friday, we have our power lunch, which I think 350 of some of you showed up last week and the week before, and we've got a really dynamic panel. We want to bring optimism and opportunity to the community. So that's our goal. And lawyers were unfortunately or fortunately made for chaos. So at this point, we're all in, and we're working hard to try to help the situation. So thank you for coming out today, and please feel free to contact any of us for further questions. Thanks again, and stay safe, stay well.